Hello, everyone. This is Gilbert Jalon. I'm talking to you here from Private Corporate Counsel, downtown Orlando, where Tufts on Tax. You can reach Mr. T. Scott Tufts at 877-647-7887. And you can dial that number on a 407 number, which is 407-647-7887. This is Tufts on Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts. When it comes to taxes and tax litigation and tax law, he is the expert and the master. Hello, Scott. How are you today?
Hey, good to be with you.
Good to be with you too. And we are talking today about the Murray case. What is that all about?
All right. So we have the Kansas Supreme Court on April 5th, 2024, deciding that in the case, the shareholders of Miracorp Inc., had brought a suit for a number of things, including breach of fiduciary duty and unjust enrichment, conversion, fraud, and an action for declaratory judgment, an action for an accounting, and misappropriation of trade secrets. The case was dismissed for the statute of limitations, and the reason why was that they brought their suit in 2016, but the court determined that their injuries were reasonably ascertainable in 2011. And the idea here in this case is, why were they on notice? And so, since we are a podcast that talks about taxes and tax forms, what have I said so far about any tax form? I haven't said any, right?
Not at all.
Okay.
Just a few.
Right. But I haven't said anything about how tax forms or taxes played into this. All I said was that this is a case, Supreme Court of Kansas, went to the highest court in Kansas.
Yeah. And
it's dealing with a statute of limitations issue. And again, case gets thrown out in 2016. And the question is, well, what were they on notice of in 2011 that led the court to believe that they should throw the case out because they waited too long?
So how long this case has been going on?
Well, it went through appeals, right? So if the suit was brought in 16, and they filed an inspection right in 2019, which was, some amended complaints. This is how litigation goes. And in the defendants don't just sit there. They try and defend on the basis that you waited too long. Okay. So what did they do that made them wait so long? And what we're going to find is that in the case, there were rumblings of problems. And what, for our purposes, what gets interesting is that in 2011, the corporation was issuing K-1s, which means it was an S corp, and it was issuing K-1s to its owners. Okay. And there was notice of some problems. Okay. And the K-1s at issue put them on notice that something was terribly wrong.
What kind of problems?
Well, so one of the things that the question began was, the court viewed it as when the ground began to shake and you were on notice of a problem, right, of injuries being caused to you as a shareholder, okay, when are you first on notice? And the court has used, in Kansas at least, the concept of ground shaking. In other words, triggering an obligation to investigate. So, Gilbert, if we were sitting here and the ground started to shake, could we just sit here and act like nothing? Or might we have an obligation to investigate? Well, that's the concept, okay? And if we were owners of the building, right? You see where that goes? Then we're on notice of something's wrong, right? So the question becomes, what is it about a K1 that might be the equivalent of the ground shaking? And I see you're smiling. So believe it or not, a K1 tax form might be equivalent to the ground shaking. And you might ask why that is. And it might be because there are changes on the K1 from one year to the next that should have put you on notice of some things. Okay. So, in other words, there's no activity being reported, and you know that there should be, right? So it's things like that, right? So when the court talks about it, it says, and this is what I find interesting. It said that by 2011, the Murrays knew that the Garmin was using Miracorp's name and logo. They also knew that they had never received any payments from Miracorp and that there had never been any shareholder meetings. Through the 1989 agreement, the Murrays also know that Robert Murray was, at least on paper, the secretary and stockholder with a 5% stake in the company. As such, he had a right to make good on his insinuation that he wrote in a letter in 2011 that he would file an inspection lawsuit under Kansas law if they failed to work things out. In other words, he says, I'm going to look through the books, right? So it's uncontroverted that Murray was, it says it is controverted that Murray was ever an officer of the company. The results of the inspection lawsuit proved that the Murrays could have prevailed if they had brought their lawsuit on time, all right? But the question is, should they have investigated sooner? All right. And so they did nothing from 2011 until 2016. And the question is that unreasonable? Meaning that they should have done something. All right. And the court said, even if we find that the Murrays' suspicions in July of 2011 did not trigger their duty to reasonably investigate, right? The subsequent 2011 and 2012 K1 statements added to the mounting evidence that something was rotten in the company. As noted, the 2012 K1, which doesn't come out until August of 13, right? Put them on notice. Okay? Now, this is interesting to us because we want to understand what's going on and why it triggers a duty to do something. And apparently, they did nothing after, according to the court, they received the 2011 and 12 K1 forms, right, which showed unusual changes in the business, such as the disposition of assets and the transition of ordinary income to royalties as the sole source of income. In other words, the K1s show a normal way of making money and shows your, and it gives you the heads up about making certain business income. And then all of a sudden you get a K1 that says it's not in business anymore. It's got royalty income. See that? Kind of a nuance, right? But so our folks out there need to know that if you get K1s, you can't be blind to them. You have to look at the details because it could put you on notice. And so the idea is that it did, according to the court, and triggered what they felt is a ground shaking or duty to investigate. All right. So we all have to recognize that in these cases, what might that look like? And one of the things that I noticed was that I was just looking at the concurring opinion to see if they focused in on anything on the K1. Yeah, it doesn't say too much. I mean, there's some question in the concurring opinion But this is the point being that
what do we learn from this?
So what we learned from it is that be vigilant, right? Be vigilant, and if you're,
and we try to say that on every case, in every form,
I understand,
right?
but what I'm trying to do is, if you're litigating cases, if you are involved in a business that has a pass-through business feature, meaning it's got a K1, you can't just throw it in the cupboard or in the drawer and not look at it, because it's much more detailed than you think if you've not examined one of those. And if you understand the big picture of what it says, you might have an obligation then to look at it in detail. And so what we're learning from this Murray case is you can't just put it in the drawer. You want to look at it. Why? Because it might put you on notice of some problems, right? So
they saw the signs and they ignored.
Yes. Hey, what's that sound? Everybody look what's going down.
Yeah, I mean,
right?
It seems like it keeps happening, like different cases from different angles.
I'm trying to focus on that, because the other aspect of this is, if you get a K1 and it's not correct, or you don't get a K1 and you should have, then we've gone back to, that's that 8082 that has to get filed to say something. You can't just pass it off and move forward. Okay.
And companies like that, big companies like that.
Yeah, you could be in a big company.
They have people to monitor and take care of things and keep up with things. Why would they think to, like you said, keep it in the cupboard?
Well, it's not the companies. Remember, this is the K1 is for the shareholder, right? The owner, the member.
Yeah.
So you might be a 10% owner, 5% owner. But if you don't look at your K1 to know,
but you still,
whatever, then you may miss the opportunity to see something that's not what you understand, or worse, that's improper. So you have to dig,
Of course.
And you got to look at your operating agreement or your agreement and see if there's any restrictions on how much time you have to inspect and look at the books and records and get to the bottom of it.
Be on top of it, and like you said, be vigilant.
Yeah, exactly. So that's the message. Getting after it and figuring out what's what.
Yeah, folks, keep and stay vigilant about everything regarding your forms, your agreements. As Mr. T. Scott Tufts said, you can reach him at 407-647-7887, or you can email him at stufts@pcc.law. That's stufts@pcc.law, or you can visit the website at privatecorporatecounsel.com. Thank you and have a wonderful day.